Okay, good evening, everyone. First off, my name is Scott McCall. I'm the city manager. I want to thank you so much for coming out tonight and joining us. We really appreciate the fact that A, it's a very nice night out, and B, this is probably not where you want to be. I will speak. Oh, there we go. They turned it up. All right. My apologies. My name is Scott McCall. I'm the city manager. What I was sharing with the folks apparently just in the front is, want to say thank you so much for being here tonight and coming out and joining us. I know you'd probably rather be doing something else, so we really appreciate your willingness to come out and have this community conversation. At this point, I'd like to turn it over to Mayor Karen Howe to kick things off, and then we will do the presentation after that point.
Thank you, Scott. Oh, hold it away. Holy cow. Okay, so there are still a couple of seats, like 1, 2, 3, 4. So if people would like to have a rest, there are some seats up front. So good evening. And again, my name is Karen Howell, and I'm the mayor of Sammamish. And I'm speaking to you on behalf of my colleagues who are here tonight. So I see Councilmember Sid Gupta, if you could raise your hand. Deputy Mayor Amy Lamb. Councilmember Pamela Stewart. And do we have any others? Oh, I'm so sorry. Well, I guess we have Councilmember Roisin O'Farrell in the corner, over there. Okay, in the corner. So on Sunday, Deputy Mayor Lamb and Councilmember O'Farrell and I were graciously invited by you all to your neighborhood. So we got a chance to stroll around and look and just get familiar with the neighborhood. We also spent about a couple of hours at Coffee with Council and talked to different to residents as well. And we really appreciate this opportunity to connect with you and to talk with you and to learn and listen to what you have to say and to understand your concerns. I want to thank you for coming out for the June 3rd and June 10th council meetings, as well as to those who wrote us emails, submitted comments, and thank you for getting engaged and for helping us to bring to our attention where we fell flat. Because through that, you're here tonight, and what we're optimistic about, proposing a solution to work through this. So we made a mistake, and we moved way too fast without a solution in place, and we recognize that we've lost your trust. Trust is so hard to get back after you've lost it. And so we know that this is going to take time to earn it. And we are going to earn it one step at a time. And this is one of our first steps into earning it back. So we heard you loud and clear. We unanimously voted to continue serving the streets in Inglewood that the city has historically maintained, and we've directed staff to work a long-term, permanent plan. And tonight we're here to share a permanent solution as we work to rebuild that trust with your community. We also heard that you want your questions answered, all of your questions answered. And we have a presentation that will address the main themes that we've heard and among all the questions that have come forward. And after the presentation, we want you to take some time and talk to staff and get your detailed questions answered. We're really optimistic that the presentation that you get will actually answer many of the questions, maybe most of the questions that you have. But if not, we have people here that are prepared to go into detail with you and spend time and make sure you feel like you get a thorough answer to the question that you're proposing. So my colleagues and I will stay in the room. We will be participating. I'm going to turn this over to the city manager, Scott McCall, to conduct the meeting. And I want to just add my personal thanks. Thank you for taking your time. Thanking you for, being the catalyst to make this change. And we appreciate it so much.
Thank you so much, Mayor and Council. I do want to thank the Mayor and Council for their continued leadership on this and for providing us the direction to move forward and work on a solution. So with that, why are we here? we'd like to share a long-term solution for the historically maintained streets in Inglewood. As the mayor stated, we'd like to respond to the themes that we heard. We got a lot of feedback. And like the mayor said, we want to thank everyone for providing your comments, questions, concerns. And we put them into some large themes because they were sort of lumped in that way. And we want to be able to respond, and we want everyone to be able to see the main themes and responses before you go to the stations that the mayor mentioned, where staff can give you more detailed on those answers. And, oh, thank you, Mike. Well, I think we jumped ahead. All right. Let's go one more. So, as the mayor said, the interim solution that council adopted on June 3rd maintained the services in Inglewood while we are working on a permanent solution. That means there will be no disruption in service. There will be no change in service.
Just right off the bat, am I interpreting right that a prescriptive easement requires all of our property, the road, to be declared private before a prescriptive easement can be issued? It's usually to allow a trespasser on private property.
So I appreciate the question. You're jumping just a little bit ahead of me. So if you can stay with me, I appreciate that. If you can just hold tight, we'll work towards that. So the permanent solution is called a prescriptive easement. It allows the city to continue to serve and regulate the right-of-way. And the city council has authority to take that action, and we anticipate that we will get it to council before the end of July for that permanent solution. So to get to, I think what you're addressing is what's the problem, right? So it turns out that we have found out that the streets in Inglewood are not public. They are actually private. And that means that technically we don't have authority to regulate the right-of-way, that we have been regulating and maintaining some streets in Inglewood where it turns out that we probably shouldn't have been. And we can't spend taxpayer dollars on private infrastructure. There's actually, the state constitution says that that's not allowed. Hang on. It's just
King County also maintained that entire area, and it's been probably 70, 75 years ago. In actuality, from the time that this plat in 1889 was put in place and notarized and recorded, King County was up there. King County was a county. Right, so they also maintained it. So somewhere along the way, somebody missed the 5 years.
So bear with me if you would. I know these are all questions, and hopefully we can get you there. And again, trying to answer everything, we need to get a little bit of context ahead of time, if you will. It wasn't a question, it was more of a statement, and it was getting to the plat that was issued in 1889 that said that the roads were public. And so we're getting to, if you'll all just be patient with me for a moment here, we're getting to that piece of it. So, but one of the things that I want to point out is that the right-of-way includes, when we issue right-of-way permits, it is regulating the right-of-way. And that means a lot of times that if, for instance, utilities are going to come in and do work, they might be in the right-of-way. And it might look like your front yard, but it might actually be right-of-way. So this is kind of a critical piece for us to be able to be clear that we have legal authority to authorize someone to do that. So the problem that we faced is when we found out that that legal authority was not there, we have a problem. So as the mayor stated, we identified the problem and we moved a little fast without the solution. So
So to that point, for utilities, is there a franchise agreement?
So if I understand that you have questions, if you will bear with me on the presentation, I think we will get there. Well, I think it's hard if you're going to ask questions every time. I appreciate that you have a lot. This is why we'd like to go through the presentation, and then if there are specific questions, we can try to address them at the staff table. So I appreciate it. So hold tight, hold with me here. Next slide, please, Mike. So I want to address the major themes that we have heard. So, how and when did the city learn that the streets were private? To the questions that have been coming up here in the front, how on earth can it be possible for the Inglewood streets to be private given that they have been served for years and years and years? We agree. That's a how on earth question for sure. Why is the city required to take action? Right? That's a question that came up a lot in various forms. And with both the interim and permanent solutions, what does that mean for the Inglewood neighborhood? So, this came up in late 2024 when we were reviewing a permit application for a single-family home construction. And the team tries to do their due diligence and really make sure that we are doing things the right way. There was a question of access to the property, and it was unclear whether or not the city had the authority to regulate the road. And again, this is that important piece about whether we have legal authority to regulate the right-of-way. So it led to further research, kind of like pulling on the string of a sweater, and further research sort of emptied the sweater onto the floor in a pile. And we wound up having to look at the entire plat. And when we did that, it was confirmed by previously identified case law that all streets in Inglewood, it turns out, are private. So now stay with me here. Next slide, Mike. So this is where it gets arcane and confusing, and this is not necessarily going to sound logical. The other piece that I should have stated at the front is that this is being recorded. The presentation will be up online. It'll be on the Inglewood page of the website once this is all over. So if you don't get everything this time, it will be available for you. It's something called a non-user statute. And what it says, if it hasn't been used for 5 years, then the order is made to make an order to actively grant opening it for public use, then it is vacated. Now, the weird part about this is that the city couldn't find any records during the time where this applied between 1889 and 1895. Now, I know we're going way back in time, but this is where things get really arcane. The Inglewood plat does include language dedicating the streets to the public. However, that turns out the non-user statute supersedes that language. So there was a 1909 revision. However, that revision was not retroactive. So it didn't go back into the 1890s, which is, well, you ask the question, who cares? Well, it turns out legally, unfortunately, we have to care. So here we are.
But we don't have any records of that, is what you're saying. Those years, we have no records. It's just city interpretation.
So I understand where people are coming from. This sounds arcane. And no, and I appreciate that. So the short version is, and it's a fair question, the short version is, even though it was on the plat that it was made public, the non-user statute law after that required someone to go in and actively activate the road and declare it public, and that did not happen in that 5-year window over 125 years ago. I mean, I never thought I'd be standing up in front of a crowd talking about this, but here we are.
But we don't have records.
There is records.
There is records. Okay, that's what I'm trying to figure out. Because you're missing that.
So hang on. But the problem is that there are not records that declared those streets public. That's the issue.
Either way.
Correct. But there are records back from that day because we all have seen the plat, right? So there are records. What there are not are records that show that the roads were declared public after that point. And then the non-user statute made them private. Now, I know this is really weird and arcane, and again, this is why we have some help in the back from folks that have a little more experience in this. But what I want to share out and what the important piece here is, legally, our understanding is now that the roads are private. So if you'll bear with me, so that is step one. So this is kind of a history and timeline. I'm not going to go through all of it, and it is a little bit confusing, but the gist of it is that to a lot of your points, they've been maintained for a long time, both from the county and from the city in the past. Want to be honest about this. The city knew about this in prior years, and previous administrations chose not to take action, but where I am and where I sit, we take on the responsibility of dealing with things when they come up. And so here we are. We know about it now, I know about it, and we have an obligation to and a responsibility to take action. So that's where things are at the moment. So what's required? Due to the streets being private, again, the city has to take legal action to essentially declare them public. And a prescriptive easement allows us to declare them public and ensures that we don't bump into the issue of the what's called, I'm blanking, it's a long day, close, to that you can't do a gift of public funds, right? Right, has to be, public funds have to be spent on public benefit. They can't be spent on private benefit. Short and simple from that perspective. So what does the interim solution mean? The interim solution means that the council directed us to continue city services without interruption. So you will see no change in the time period while we were working towards this permanent solution. So does that mean we are sitting out a little bit shaky on legal ground? Yes, but we think it's the right thing to do. So we're going to continue to do that. Council directed staff to identify a permanent solution. We have been working hard on making sure that that it fits for everything that we need it to do. And the interim solution remains into effect until the permanent solution is put in place. So the next step is, what does a permanent solution mean? So this is the part. The prescriptive easement is the legal right to maintain and regulate the right-of-way. Now here's the kicker. It can only be asserted, to your earlier point, it can only be asserted when jurisdiction has maintained and regulated the right-of-way for 10 years of open, continuous, and uninterrupted use. So the traditional streets that we have maintained in the Inglewood neighborhood, that falls into that category. So we are able to use the prescriptive easement to address that issue. Now, I want to be clear about this. There are roads in the Inglewood community that traditionally have been private and that we have not served. We would not be able to apply it to this. So this is really about the roads that we have traditionally served over the last 25 years, 25 plus years, we're a little past, but during that time period. So we are developing legislation to assert the prescriptive easement right. The permanently declared historically maintained streets allows us to continue to serve moving forward. It's a permanent solution. And it does require council action to legally allow us to be able to do that. And again, this is not just to go out and do what the work that we do in the right-of-way. It is allowing us to issue permits for someone else to do work in the right-of-way. So, I talked before about publicly versus privately maintained streets. Hopefully most of you have had a chance to see this map. There is, in the back, there is a version of this that you can go look at. But prescriptive easement rights can only be asserted in those streets that are, it's sort of the darker colored streets. Next slide. So the easement ensures that we can continue service delivery. And so these are all the different types of things that happen in the right-of-way. Not only do we do our city maintenance portions, but we regulate it. We issue permits so utilities can be in it, and it allows other public things to happen in it. So all those things are part of that prescriptive easement. So it would make sure that all that stuff would happen, just like the way it is today. So what are the next steps and timeline? As was stated before, we continue to serve the community with no stop in service. Legal counsel is drafting the legislation to assert our prescriptive easement right. We are hoping that the council will deliberate and adopt the prescriptive easement legislation by the end of July, but I want to be clear about this. We made a mistake moving too fast the first time, so we are going to make sure that we get it right. We want to make sure that everything lines up correctly and that when we bring this, it will be a one-time final solution. And so we are aiming for the end of July, but if it takes us longer, I ask your patience and know that nothing will change in the meantime. Additionally, the city is developing citywide public works standards over the next year and a half, and we will collaborate with the neighborhood to recognize the unique nature of your streets. Because as you all know that live there, they look a little bit different at times than some of the other streets in the city. And we want to recognize that and work with you all to get to what those should be moving forward. And again, the interim solution remains in effect until the permanent solution is adopted by council to take that legal action. So none of the services will change that you've traditionally had. They will continue on without interruption. And so tonight, I know there are a lot of additional questions. We have our entire leadership team here. We have some stations out. Some of you had a chance to address them at the beginning of the meeting before the meeting started. We are here to answer your questions. We are here to engage. Council is here and will be staying in the room more or less and around in the area to engage with you all. I want to thank you all for coming tonight and listening. I appreciate you giving me the opportunity to give the presentation and get all the way through it. I know that there is some frustration, but at this point, I think we'd like to invite you all to come join us out at the different stations and engage on both the questions and the solutions.
Before you divide us and try to take us on in kind of groups, and I'm not trying to be conversational, can we get through at least a few questions with regards? Because I think some of us would challenge some of the things you're saying. Especially, let's go first talk about. First, I want to recognize the effort that
Get the mic.
that
Get the mic. Get the mic.
Yep. Just if you'll be patient for a moment, we're going to get a second portable mic, and then we can ask some questions and do some Q&A. If you'll hold that for just a minute.
I was just going to thank the city council for taking action swiftly. Bring this
Check, check, check.
If you'll hold that for just a minute, we'll go one at a time.
Okay. Yeah. So a couple things you know about the proposed solution is there is. Okay. Okay. Thanks. Okay. So the proposed solution, I look at it as a fallback, and I passed out some documents earlier this evening. Some of you have them. If you've read through them, please hand them on to your neighbor. The prescriptive easement, one thing that's not being shared, and it may be for lack of knowledge, is that that's assuming that the non-user statute applies, in that the streets and the property that the streets run over returns to the adjoining property owner. Okay, so what that and it has to be recognized by an action either by the property owner or a government entity. But that property then gets added to your property, increasing the size of your lot, okay, which has tax implications, which has insurance implications, and the other piece of it, without a formal agreement as far as the services that the cities can provide when it comes to maintenance, they could revise those down the road and provide a minimum level of service and maintenance to our community. Again, would force us, in order to protect our rights, would force us to organize a homeowners association, which again would be another tax. So it is a solution, and I appreciate the mayor and the council looking into it, but it's not a solution that doesn't have financial implications for the people of the community. Two other things, just quickly. One would be that I would challenge the one thing that the non-user statute from back in 1890 is self-executing by order of law. So if the streets were not open for a period of 5 years, they automatically revert back to the property owners, and that's what the city's position is. But yet, we know from historical records that the railroad was running through the width of the Platte along the lakefront. There is a road adjoining that. A public railroad, just so you know, is considered a common carrier and is referred to in case law as a public highway. Okay. In addition to that, we know that there 3 weeks, I believe, after the Platte was dedicated on July 23rd, 1889, there was a post office that was put in place next to the railroad, believed to be next to the railroad tracks. That was originally, the postmaster there was one of the property owners, John Ayers. It then was taken over by another couple and their family, which ran that until it was moved to, I say Weber because I went to Weber State University, but Weber Point up north of where Inglewood is today. And then we also know there's a one-room schoolhouse up on the plateau, which we can assume that families and squatters and maybe Native Americans that had settled either within our plot, therefore opening it up by default to public use, and the community around were served by that. And they would need a way, because there's no way to get there other than transiting through, at times, for the people that were close by our plot, through our plot itself. Again, showing public use. Yes? Yeah. No, the court, the case law, and again, I'm not a legal professional. Okay, case law, then, so case law indicates, so let me, okay. No, I disagree with you. And then so just one thing, and so we're not going to settle the non-user issue tonight. I absolutely agree. So let's then talk about RCW 3675070. Okay.
So hold on. Hold on.
Which, just let me quickly summarize that statute. That statute says a public highway that's been operated at public expense for a period of 7 years, and these roads within our community have been operated for 50 plus years, first by the county and then by the city, revert to public roads by default after 7 years. It does not require a formal resolution by the county commissioners, as does the RCW that was referenced earlier this week in the council meeting, which is 3675080.
So I want to address just one piece of this. I appreciate the comment.
I'm just wondering.
So hang on, folks. If I can just take a moment to answer. So one of the pieces and one of the reasons that we wanted to share out and have this community meeting is that we have done extensive legal research, and our attorneys have found that the roads were not made public, and therefore they are private. And so that is that is our reality. And I understand that others might have different opinions, but we are operating on our experienced team of city attorneys that have done the research, and that these are private. So the solution, and hold tight, the solution is to do the same thing that we've always been doing, to assert prescriptive easement over the rights of way that we have been serving, not anymore, and so that it wouldn't change property values or property rights, except that the city would assert ownership essentially of the right of way, right? It wouldn't be any more property than that.
We have a counter-legal opinion of a legal person that would take our case. You can hire a lawyer. Well, that's my question.
So,
Take money out of your pocket.
Well, okay, I could do that.
Like to avoid a legal fight over this because.
Thank you. Yeah, that's my question. Is it still the city's opinion that you would like to avoid a legal fight over this? Because there are many residents here some are already talking to attorneys, some are ready to hire land use attorneys. you have 500 homes that if everyone kicks in $1,000, are you guys ready to fight that for years and years and years?
So,
No, they're not. I have a deed, or on my title report, the roads in front of my house are public. Okay, right? Anybody else here, right, have that? Hold on. There are many private roads that would not. But here's my point. Let's do, I'm trying to help the city do the right thing.
I appreciate it. Please continue.
Because I've had advice that if roads in front of my house are made private, I have about a 10 to 15% devaluation of my property for costs that a future buyer would see as an impairment, and that would be, you take the present value of the cost to maintain that over another 20 years. Do you want do you want 500 homes to file a $100,000 lawsuit each against the city?
So I appreciate the question. What I want to be clear about is I understand what you're saying. We believe, and our legal team is telling us, that if we assert the prescriptive right, it makes the road public. So for the purposes of.
Okay, here's the deal. These roads were not opened within 5 years as a statute, so they reverted back to private. Then, many years ago, 75 years ago, probably before any of you bought here, the county started taking care of the roads. And once you take care of the road, either by the one statute for 7 years or this other statute for 10 years, they are automatically public under the prescriptive easement statute. You don't even need a deed. They're public roads. All these people here at the city are trying to do. So these roads were public. Let's assume King County started taking care of them in 1940. They were public in 1950, 10 years later. However, we have to get that on record. The prescriptive easement runs after 10 years, which would have been in 1950. And the prescriptive easement says you own this property as a matter of right, not an easement. When you assert your ownership in it, then you own it 100% in fee. And what they're trying to tell you is that these roads have been public under the prescriptive easement, or it's also called adverse possession. And if people don't like the word prescriptive easement, use the words adverse possession. They're just legal terms of art. These roads have been public by adverse possession since decades and decades ago, probably before you bought. The fact that they're going to clear up this non-user nonsense has no effect on your property value.
I agree with what she said. I agree that the prescriptive easement makes the roads public, and that it does not impact your property values because it's the same as what it was before.
If they've been using it as public uses, that actually will revert back to public, or should be public.
It's been public since
It's, so you don't have any proof of this non-use, one way or the other. It just should be public, right? I mean, they're just looking
Unfortunately,
at
the
one
law
side.
doesn't work that way.
You're not looking at both sides. Someone's giving you one side of the story and not giving you both sides. I mean, what she said is perfectly right to what I'm hearing, but you're only giving us one side. You're saying, oh, they didn't use it within these 5 years. But how do you prove that? They're just telling you that. No one was there.
So
Were you there?
I understand what you're saying. The issue is, and the question is, how do you prove that the roads weren't made public? And the answer to that is there is no legal documentation that said that the roads were made public. And I understand that people are shouting out answers. We have to operate on the best information that we have from our legal counsel. That's our obligation, and that's our responsibility.
But they're only looking at one side.
I'm not sure that I would make that same statement. So I understand that there are a lot of questions. I see a hand over here, sir. Please.
Thank you. My name is Darryl. I don't know if you need to do this for the record. Mitsunaga, Mitsunaga. And I just wanted to address some of the comments. Hi. First of all, I know your legal team, and I've worked with them, and I respect them. But I don't agree with a lot of the analysis that you're making. Excuse me, that you're making here. I don't believe, but I don't really want to get into a legal argument, but this is what I want the council to consider, is to consider the fact that you've created this craziness because of what you did without contacting the community. You're trying to fix it now, but the fix is wrong because it's unnecessary. The non-user statute requires that whoever wants to take the street back has the burden of proof to show that the streets were not opened. And it doesn't require a public record. It just requires some evidentiary proof that it was opened. You can't prove that. If you can't prove that, you can't establish that it's a private road. And there's case law out there that says you've got to have an adjudication in regards to that if you want to vacate it. In my experience is that with all my clients is we come to the city's never going to unilaterally vacate. They say, you've got the onus to go out and vacate. We're not going to do it for you. Now you're switching this around. And I disagree with the prescriptive easement piece too, because you can just pull it back at any time. Yeah. It doesn't give you any ongoing, so I guess I don't want to belabor the point, but I just want to ask that the council consider whether you need to do anything, because I think you just leave the status quo. Otherwise, you're filing a lot of lawsuits, 500 separate lawsuits against all the property owners to establish the prescriptive easements, because they may apply as a matter of law, but it doesn't legally grant any rights until you have an adjudication. So.
Can I make a suggestion? Hi, I just want to make a suggestion. I love that everybody's engaged, and I love you have questions, and I love you have points. I think it's, and I'm going to channel our attorney here, we can't debate you legally in this space, right? We are not lawyers. We have to consult our lawyers. So what I think would be most productive is if all of these are sort of framed, we'll sort of play the Jeopardy rules. If all of these are framed in questions, and then that way we can have our legal team go back and we can address all of these as questions and give you responses to all of these, because we're not gonna make that legal call out here in public. So if we can keep them as questions, I think it's great, because I think we have to go talk to our legal team and say, hey, you know, he made this point. What do you think about that? What can you show us that says it's either A or B? So if that's okay with you, right? We're not saying who's right or wrong. We're saying that we're going to need to go back and make sure we do our homework and then come back to you with here's the information that we have, because we really do want to get it right.
All right, I can try framing it as a question. I think it'll be most helpful. As to potential, I completely agree. There might be just a status quo, and maybe what we're doing here is giving you more arguments in favor of that instead of, you know, the city having to do the prescriptive easement thing. And just a piece of feedback, if you actually agree with her, then your first bullet point in your second slide said, well, the roads are private. Like, don't say that if you believe that the prescriptive easement just says we're going to make them public, or we think status quo is public. I have in front of me Resolution 30575 from 1965 from the county. TLDR, it says the owners and developers of, there's 12 roads here, have caused to be dedicated and deeded to King County and a bunch of Inglewood plat roads, and it says that the county hereby accepts the roads to be maintained as part of King County road system, provided that this acceptance, etc. So there's two resolutions here. Again, looks like the county at some point said, yep, the roads are public, and we're not only maintain them, but there's this stuff, it's in the archives. And the second thing, I appreciate how your slide said, we learned about this in 2024, but then afterwards you said verbally, we've known about this for a long time, and you mentioned case law. There's at least 8 cases I can see in King County District Court where the city has been a party of, and the non-user statute has been mentioned. So the city has known for this for a while, I believe, and you said so as well, and yet keeps maintaining the roads, right? So I think that's another argument for the city believes the roads are public, and maybe on slide 2, first bullet point, you shouldn't say the roads are actually private if that's what you believe. That's all.
And then we'll get to
Yeah, it just seems like we're about ready to spend a bunch of money and time and effort and energies on something that is so simply just tear up the damn letter and let's go back to our lives the way it was. That's all.
Public road.
Okay, first of all, I want to thank the council and the staff for having us here. However, I don't think this is the time to debate the information he's going to give us. He gave it to us, we have it, we can use it however we want. There's all these people in this room that have questions besides just the presumptive. I think we should go on with our questions so that we can really get some answers. And one of the questions I have is, how did Inglewood Hill in the plat become public? I have to assume if it wasn't public in the plat, it wasn't public anywhere else. And all of a sudden it became public in 1964. Not in 1895, not in 1889, but in 1964. I don't know of any residents that live on that street, but if they do, I'd like to know if did their property deed change? Did anything change? But how did that occur so easily? And we're going through this huge mess.
Appreciate the question. If I may, that one is actually fairly straightforward, if I may. The county actually took action to dedicate Inglewood Hill Road as public, in no small part because it crossed over the plat at a diagonal. It didn't go on the traditionally laid out roads. But we can follow up on the answer to that question. And then we will follow up with the answer to the...
Thank you. It did not exist on the original plat. That's the difference. If we go look at the original plat that's out there, right, it's just the grid. The Inglewood Hill Road bisects it, so it was new and not on the 1889 plat. That's the difference.
Quick question. Hi. Okay. You have the mic. I have the mic, but he said to wait.
No, I'm sorry. I just wanted to acknowledge that there are two people in the back. If you would, we'll be here. She's got the microphone, and then we'll work our way to the back.
Really quick, if we could just reflect back on that document, if you can go like a couple screens back, would that be okay? One more. Keep going. One more. No, one more. Oh my goodness, go one more. Okay, here we go. Thank you. Because on here we have some dates, right? And I think we can all agree. But if you just look at the historical documents, it does talk about, like these, you referred to some of them. But there's also more, like 1901, Polk's Business Directory talks about the community population of 25, as an example. Obviously, people were living here. But to summarize, it's all very descriptive. It talks about the Inglewood location and the shore, and it's very descriptive about the 1890s and the 1930s, and it gets very detailed, the eastern shore of the lake, and it talks about the north. I mean, it's all right here. And only 3 weeks after the town was platted, the Inglewood post office was established, as somebody else stated, in 1889, and that was discussed. Talks about Charles and his wife Teresa in the post office. Then it also reflects again on the 1901. And the reason why I'm saying all this is because I know people have kind of put it out here and there, but it is documented and it is in the Sammamish Historical Society. So I guess that's where my confusion comes in when these statements are made like this, such when it says, oh, well, no one lived there in 1889. Well, there was like a post office and there was different buildings. And so I guess that's where my question comes in. So when you said say the question, so that's my question.
Well, can you say that? What's your actual question?
My actual question is there's historical data that does reflect on that time frame, not just the 1889, but it goes all the way from the 1889 all the way up to 1894, and then past that regarding our neighborhood and how it started out because it was going to be Inglewood and it was going to be a town, which didn't become a town, it became a neighborhood. So it talks about it. And there's a whole bunch of documentation that talks about all the different things that occurred there. And it's very descriptive.
So your question is why?
So the question is, why is that being ignored? Thank you. Thank you, exceptional neighbor.
Appreciate the question. Thank you. There's so two gentlemen in the back that have been very patient.
Okay.
I think at this point we'll take the questions in, and we will.
If you use adverse possession to take it, it implies use. And in the simplest terms, then the city should be able to take the road because the people's surveys or their lot lines don't go to the center of the road like they used to. I used to be a surveyor, a land surveyor, and in Michigan and Virginia, a lot of the people's property went to the center of the road, and then they had an easement shared by their neighbor across the street, and all the way down the block, and that was an easement for public right of way. But here all of the lots go to some distance off the center of the road. So who gets it by adverse possession? If you use that terminology, because that's not how it's laid out survey-wise. And I've done a lot of surveying for lawyers. I've done adverse possession surveys, and I've done quit claims to solve problems like this, but that's usually because the lot lines went to the center of the road, and they don't here. So who gets the road under adverse possession? Is it the people who use it? They get it incrementally because they have to drive past each piece of property to get to their own property? Or does the city get it because it is, they've maintained it, so they take some ownership to it? Or is it a combination of both? It could be, like one of the gentlemen said, it could be a mess of lawsuits. The other thing is that the original letter that came out was either written by Elon Musk or it was written by an engineer, which might be worse. And but it indicates it basically says to you, reading between the lines, that you've been getting this for free. Well, you've been paying 14% of our real estate tax goes to the city for city services. So the city's not getting anything for free. So if you take us off the city register, you don't save any money because we're going to come back and claw back that 14%. We're also going to look at it that for 25 years you've been illegally collecting money from us that you had no right to, and we could claw that back too. You're talking about millions and millions of dollars. For me right now, it's about $2,000 a year that I pay the city for city services based on my real estate tax rate. And it's real easy to go back to the city website and find out what everybody's paid for real estate. And you take 14% or whatever the percentage was during those years, you can find that information out and you can come up with a big bill that the city has been illegally collecting. If you say that it's been illegal since city's inception, and then you could even go back to the county.
Appreciate the comment. We capture the question in there. Thank you. Right behind, actually, this gentleman's been very patiently waiting.
You're ready. Thank you.
Yeah, I have one question is, regarding to your permanent proposal, is the liability. So if someone hurt in front of my door on the street, who get the responsibility? Yeah. So this is the first
city.
question.
Yeah. Uh-huh.
Yeah. And the second is, maybe I'm too, easy. So is one is how about we can just donate the part of the street to the city if this is the term of the problem is. So this is my 2 cents. Okay.
Thank you for the question. I think we have over here.
Oh, right here.
You mentioned the unique environment, the uniqueness of our area, our homes, our roads. I've always called us eclectic in a neighborhood because you've got properties that were built in the 60s, properties that were built more recently, properties that were built even before the 60s hit. So are you going to continue as a city, this is my question, are you going to continue as a city to honor our uniqueness, or will this also become an opportunity to bring us up to other standards that are known in this city when new developments come in, putting in sidewalks, for example, and all the other amenities that might be included, but the sidewalks come to mind, filling in some of the ditches that we have. I'm curious because there's a good side to those answers, and my perspective is that there's a bad side, but I want to be cautionary. I would like to know. So there you go. Put a period on it.
Thank you. Appreciate the question.
Hello. Can you hear me? Hi. Thanks for, I have 2 questions. The first is, now we know that the permit review where this was discovered was in 2024, correct?
Initially.
Which month?
Started.
Which month, please?
It was in late 2024.
Late 2024, okay. So we are in June now. So a question that I have for you is, since you knew in 2024, what were the factors that drove your decision to send out this letter to the residents with 30 days notice at the end of May, when you knew all along? And also, why did you select the June 30th as a date, as a cutoff date? Then my second question is, did your city attorney, who I don't see here, but have you consulted with outside counsel as well? Yes or no answer, please. Thank you.
Thank you for the question.
I would just like to piggyback on one of the, something that was said back there is some back payments. I mean, when I built our house in 2001, we pulled permits. We pulled permits to get into the street, and we pulled permits for culverts, and we had to abide with what the city told us to do. We had to stand up when they told us to stand up, sit down when they told us to sit down, do everything they wanted to do. We had to do all kinds of things that the city wanted us to do. So, and we've been paying taxes, and they have tore up my yard, they tore thousands of dollars of, maybe $10,000 worth of trees and stuff like that. It's not a question, I'm piggybacking on what he said, is that are you gonna, well, I guess it is. They need to figure out, are they gonna back pay that? Is that, because you should have never charged me for all that. That's my question, is there's a lot of back payment that's owed to a lot of people. Sorry about that, if that happens. But I'd rather just settle this like amicably, and I think most people would, become public streets. And this thing that they got here, I think we've proven that they're public streets.
Appreciate the statement. Thank you. I think, if I may, if there's anyone else that hasn't had a chance to speak yet or ask a question. The other piece that I just want to share, and I appreciate everyone staying with us, is that some folks don't necessarily feel comfortable in front of a group like this asking a question, and that's one of the reasons why we wanted to make sure we were accessible to everyone in case you want to have a more quieter conversation. So again, when we get through this, city staff will still be available at stations to respond to more individual questions. But for right now, I think there's a couple more.
Well, my question is, we all love our houses, but we love our lake also, and the salmons into it. What I'm gonna do is, if I have to take care during the winter of my road, I'm going to put kilograms of sodium potassium. That's terrible for the lake. That's terrible for the salmon. If I do it myself, a few kilograms is okay. If 400 people do it, it's going to be terrible after 10 years. Have you thought about it?
And I appreciate the question. And again, that's why we're trying to find the solution to be able to continue maintaining so that we are not putting chemicals in the lake. So thank you for the question.
So as a follow-up to some of the great comments here about the roads being public, why does the city not develop a resolution declaring them such?
And I appreciate the question, and
I happen to have one here for you.
We are trying to bring that as quickly as possible.
Okay, because that's the easy solution here.
And
right, that avoids. Yeah, there's plenty of evidence when the county took over or accepted the roads to be maintained and as public. There are several state statutes that once, if that road has been public or operated as public for 10 years, it stays public. Yeah, this should be simple. I think we all want the right thing. Let's avoid a lot of hassle. Let's have the council, let's have the city adopt a resolution declaring those streets that are on your map, have them remain public. If there are areas where they're not public and it's appropriate they remain private. If there are areas where there have been troubling vacations over the years, it's probably okay to carve those out as well, right? But for the vast majority, I mean, you're taking a sledgehammer to a gnat, right? Let's do the right thing. Let's keep them public for all of our residents. We all pay taxes. We've been paying taxes for years and years. You can argue there's a reserve fund for that maintenance that hasn't been used yet. Let's not have fights over residents looking to get that back. You know, it's a great question about Inglewood Hill Road. If you use the same logic to make these roads private, then you're asserting that what the county did with Inglewood Hill Road was inappropriate when they did it in 1964. If we want to go that route, you know, okay, we can put the barricades up and the toll booths will be up next Thursday, right? That too is ridiculous in the extreme. Okay.
I appreciate it. And I do want to say our goal and our aim is to get to that solution for sure. So we appreciate that. So at this point, thank you, everybody. I think what we'd like to do is offer up to that. And we heard your questions. I see we have one more. So let's do one last, and then we'll move out into for those that would like.
Okay, so the city's been taking in a lot of questions. We're not getting answers now. If you continue with the prospective easement instead of declaring the roads public, will we have an opportunity to see that before it's voted on?
Yes, absolutely. And we will get that out as soon as it is ready in draft form. We will get it out for the community and council to review.
Thank you. Thank you for having this meeting and hearing our questions. I have a question about prospective easement versus being made public, because some of the things I'm hearing sound like prospective easement is making the road public. If you do the prospective easements, do our roads show up as public streets just like all the other public streets in Sammamish? Or is that somehow separate? It scared me a little when you talked about the unique nature of our streets regarding the prospective easement. So I'm not clear whether prospective easement is the same as declaring the streets public, or is there a difference? And if there is a difference, what is it? And how will it impact us
That is a great question. I'm not an attorney, so we will have to get back on the last part of that. But what I do know is taking the action effectively makes the road private. I think that, public. See, it's been a long day. My apologies. Public.
But you said effectively. You didn't say it made it public. You said effectively.
Again,
Those are two different terms.
I understand I'm not an attorney, and we do need to answer that, so I appreciate that. I would also say about the uniqueness of what we were saying about the uniqueness of Inglewood roads is that, to someone pointed out, they are not the same standard as everywhere else. We want to honor that and understand that we can't necessarily do that because it would take people's homes in order to do it, and that's not right. So we want to work with the community to find the right solution, the right fit, to be able to continue to serve the community, and again, to be able to assert our legal authority to issue right-of-way permits and regulate the right-of-way, as well as serve the roads that we have traditionally served. So with that, I really want to thank everyone for staying with us. The staff will be out at the tables in the back. We would encourage you, the council is here to engage, and thank you so much for coming out tonight and sharing your questions and concerns.